everyone. I know our faculty presenters have a lot of material to cover today, so without any further ado, I'll turn the floor over to Dave Wagner. He's a member of our Energy and Natural Resources group here in the Pittsburgh office. Dave?
Hi, everybody. This is part of our quarterly environmental and energy teleseminar series, and today's focus is really on U.S. manufacturers, retailers, and distributors, and what they need to know in terms of environmental regulations affecting products, which is a big category, as you'll see. I'm excited to be joined by my colleagues Nicholas Rock in London and Jamin Bullock in San Francisco. This will really help us take a broader look at these issues, really a global look at these issues. And I think it really underscores what Reed Smith has in terms of a global environmental expertise. So with that, our overview for today, and it is just that. This is a real 20,000-foot perspective. We have 1 hour to really give the high points on this issue. Also, I think we'll be tight on time, so if you don't mind, any questions you might have, please email us, call us after the fact. We would love to hear from you for sure. So we're going to start obviously with, or talk about product-focused environmental requirements and trends. I'll discuss this development on conflict minerals. We're actually going to go then to Nick Rock in London to talk about those 3 acronyms, ROS, REACH, and WE in the European Union. He'll get into those in more detail, but ROS is a substance restriction law, REACH is the European Union's chemical law, and WE only sounds fun if you enjoy taking back your products when their life cycle is over. So that's their electronic waste take-back law. Then we go to California, where there's always new things happening in California. Of late on this issue would be their green chemistry program. And then we'll come back to me to wrap it up and talk briefly about extended producer responsibility, which is a catch-all term for some of the take-back or end-of-life requirements you're seeing for products. And then we'll talk briefly about what to look for as these issues go forward. All right, so in general, to give you some context here, we've had for decades in the U.S. Regulation at the end of the pipe, whether it's a smokestack, whether it's a pipe going into a waterway. We do a pretty good job at regulating that type of pollution. What we're seeing now with products are mandates on things like the design of the product, what you can put, what you can't put, more particularly into a product, what you might need to do in terms of energy efficiency for a product, as well as what you need to do when the product is done with its useful life. You can't just put it on the market and it's gone forever. In some cases, it comes back to you. You need to deal with that. And forcing this issue are, governments, the laws that we've listed and we'll talk about today. You see government procurement requirements for some issues. You have consumers that have more green awareness and preferences, non-governmental organizations that have different scorecards to try to name and shame companies into action. So several pressure points, and of course we're hoping to help you identify and try to manage these issues. I guess one more context slide, if you wouldn't mind. I wanted to just emphasize that we're talking about, today's presentation kind of goes along this path of looking at the life cycle of the product and where you're seeing regulation at every point in that life cycle. So it begins with the sourcing of materials. And these aren't exclusive, they tend to overlap. But it begins with the source of the materials, how you need to manufacture or design them, what you can use, what you can't use, what the market access is requiring you to do in terms of limitations, restrictions, notifications, record keeping, labeling, those sorts of things. And then finally, what you need to do in terms of collecting, reusing, and recycling that product. So, as I said, I'll start with conflict minerals. Just want to mention as an aside that with respect to material sourcing, there's also restrictions with some timber and plant products as well as with these conflict minerals. But at the root of it, and we'll hear this a few times today, is it is really about trying to manage your supply chain, dealing with those challenges as well as what the public might expect you to do. In terms of the conflict minerals, it triggers from this horrible conflict in the Democratic Republic of Congo, and the revenues from the mining of these various minerals, which I'll identify in a minute, are seen as the key driver for this conflict. And the idea is, let's use market power of, say, downstream users to limit the financing through supply chain transparency, through supply chain disclosure. So it's, again, triggers from minerals from the Democratic Republic of Congo and their adjoining countries. And you see this legislation as part of the Dodd-Frank Act, which was the financial reform law back from, I think, July 2010. And here's sort of the legal terms that start the whole process. You need to disclose if conflict minerals or the metals derived from conflict minerals are necessary to the functionality or the production of a product that the company manufactures or they contract manufacture. Of course, terms like manufacture aren't defined by the rule, and as I'll talk about, there's plenty of gray area that pops up pretty quickly. But keep in mind, it is not a restriction, not a prohibition. It is a disclosure requirement at this point. And it applies directly to companies that report to the SEC and indirectly to their suppliers. In terms of minerals at issue, by the way, I'm on slide 7 if you want to keep track. There's 4 main minerals at issue. I've listed their name and their common names. So you have columnite tantalite, known as coltan or industrially as tantalum. It's used in electronics, airbags, jet engines, and drill bits. Tin is another mineral. You find that in solder, paint, and tin cans. Tungsten, also metalworking tools, drill bits, and electrodes. And then also gold, which we find in electronics, semiconductors, and jewelry. So we're talking about a lot of affected industries. Electronics, for sure, automotive, jewelry, some of your tooling industry, paint, pretty far reach. I had a joke in there somewhere about the old-fashioned phone to the modern phones, but you have to fill that in. But it's way more than tin cans. It's way more than phones. Again, this is an overview today. So the simplified 3-step process for what you need to do if you're concerned about this, you think you might have conflict minerals in your product. So if you first determine your applicability. If you file a report with the SEC, if you manufacture or contract to manufacture, or if the conflict minerals are necessary to functionality or production, well, go to step 2. Find out, conduct an inquiry about the country of origin of these minerals. After that step, then exercise due diligence on your supply chain and file a report that's audited and certified with the SEC. And again, I should have underlined or bolded simplified because there's a lot of issues to consider here. And I just want to touch on a couple things that jumped to mind for me. First bullet, you only disclose if the conflict minerals are contained in a product placed into the stream of commerce. So if the mineral is used in operations but not in the final product, it's not subject to disclosure. I think an easy example would be with software. If you have a video or music streamed or downloaded, the product would probably be the content, I would argue, not the servers or the transmission lines. If you're selling media in physical form, like a DVD, that could constitute part of the product, and I think at least further inquiry would be required. So there's all sorts of those issues to think about based on what your product might be. As I mentioned on the second bullet, manufacturer is not defined by the rule, and whether a company contracts to manufacture a product depends on the degree of influence it exercises over the materials, the parts, the ingredients, or the components to be included in the product. So there is some guidance in the rule. This is more than putting your logo on a product. It's more than servicing or repairing a product manufactured by a third party. However, keep in mind also certain derivatives are excluded, certain stockpiles are exempted. There's issues, and again, I picked out sort of a law school exam, spot a few issues. How far down the ownership chain does the company need to look? I would argue subsidiaries, probably yes. If you have a joint venture or a minority investment that you don't control, probably not. Jumping over step 2, the country of origin, into step 3, the due diligence. Right now the main due diligence process is through this international OECD due diligence guidance, and has some predictable things in terms of identify supply risk, audit, file a report. But the gist of it is, if you've done your due diligence and your product is deemed to be conflict minerals free, you still need to file an independent audit and certification. If you've done your due diligence and you're not conflict mineral free, it's audit, it's certification, identify the products, identify the process facilities, and explain your efforts to identify this and work through this process. Well, sounds a bit onerous. You might be curious about when you should be doing it, and the answer is probably now or extremely soon. The first reporting period began January 1st of this year, ends December 31st of this year, and the first disclosures are due to the SEC by May 31st of 2014. There are, as I said, exemptions in terms of timing. For example, if your conflict minerals were outside of the supply chain, that is smelted or refined, or already outside of the conflict area, before this year, you're probably exempted. So there are things to consider, but it is happening in real time. Some of the tools available would be your own supply chain management practices. There are templates put out by industry groups. This is the Electronics Industry Citizenship Coalition, combined with the Global E-Sustainability Initiative. IPC is a trade group. They have materials, and there's international guidance through the OECD as well. It's certainly worth mentioning that there is some litigation as we speak. The U.S. Chamber of Commerce and others have petitioned for judicial review. I've listed some of their legal challenges. Nonetheless, the rule remains in effect pending judicial review. Oral argument is in a few months on May 15th. Seems to me, though, this rule, though, is not going away. You need to notify suppliers, notify or figure out what you want to ask suppliers. We have some checklists that we put together. We have a flow chart that we cribbed from the SEC that might be helpful. We have former EPA attorneys like myself, former SEC attorneys also at the firm to help you guide you through this process. What's curious about this, as I turn this over to Nicholas Rock, is here's one case on conflict minerals where the U.S. is a bit ahead of the EU in terms of trying to be responsive to environmental concern. Typically in the past, as Nick will talk about, the EU has been out front with some of these product issues. So with that, Nick, I turn it over to you to talk about developments over there.
Okay, thanks, Dave. Can you hear me okay?
We can hear you.
Dave,
Yeah.
can you? Okay, great. Thanks. So hello to everybody, whether that's good morning, good afternoon, good evening, wherever you are, from the European and Middle Eastern environmental practice of Reed Smith. I'm not going to follow the slides too slavishly. There's quite a lot of detail in there which people can study at their leisure afterwards. I'm also, I can tell you, I'm not sure what you can see on your screen, but I'm sitting at the end of a very long, thin conference room, and I'm at one end, and the little tiny television with the slides on is at the other end, and I'm kind of an age now where that's a challenge for my eyes, so I'm going to try and give you the right signal, Dave, to turn the slides, but maybe if you see me going awry, you could do it for me. So the European Union, as you say, likes to see itself as out front and leading on a lot of environmental issues. Those of you who know anything about emissions trading and aviation will have seen how that can go badly wrong. The European Union has now and has had for some time a very highly developed and sophisticated range of legislation and softer law guidance, etc., within the sphere of what we call producer responsibility, which is essentially an extension of the polluter pays principle insofar as products are concerned. And there is, as I say, a range of legislation really designed to regulate products from the cradle to the grave in terms of their composition, their design, their packaging and labeling, their marketing, and what's to happen to them at the end of their life in terms of waste collection, reuse, etc. And on the first slide that you've got there, I've actually just listed by way of example, and it's not an exhaustive list at all, various other key EU legislation that falls within the umbrella of producer responsibility, in addition to the topics that I'm particularly going to talk about. I should just add before moving on, for those listening in who were not aware of our environmental law capabilities outside the US, this is, I guess, one of the most black letter law areas of our practice, if I can call it that, and it's only a relatively small part of our practice in terms of the overall scope of everything else we do, from environmental litigation through brownfield redevelopment work, project development, both on and offshore, transactional work, etc. So just really wanted to make sure everybody was aware of the capabilities that we have both here in London, but also in Paris, in Germany, and in the Middle East on environmental. But within the sphere of producer responsibility, I wanted to particularly focus just on three areas. And as Dave said, this is an area that's bedeviled by acronyms, and I'm going to be talking about three of those: REACH, WE, and ROSS. Next slide, please, Dave. So a few of the features that all of these bits of legislation have in common, and I'm sure that the position is similar in the States, all of this legislation is extremely complex, and even if the legislation itself it might be relatively brief, and let me tell you, in the case of REACH, it certainly is not. It's a whole world of pain. It's also underpinned by massive volumes of guidance. So the REACH regulation itself, the guidance underpinning that probably fills 3 or 4 lever arch files. And so for those listening in who are from within Reed Smith, who might sometimes be surprised when we can't just give you a quick 5-minute answer to a question about WE or REACH, that's why. This stuff is incredibly detailed and incredibly complex. And it's vital to get it right because it's criminal in nature. Offences for breach of this legislation are criminal, and they are robustly enforced in the EU. People sometimes look at the maximum penalties for individual offences and think that they're quite modest, and sometimes they are. But if you are supplying hundreds or maybe thousands of products into the EU and those products are not compliant, it's important to bear in mind that each supply of each individual item is a separate breach. And so what might seem like modest fines can very quickly mount up to a very large sum of money indeed. The other thing about criminal liability, and environmental lawyers always say this because it makes people sit up and pay attention, but it's true, is that this legislation can also give rise, in the case of breach, to liability for directors and officers and not just the company itself. And we've seen regulators across the EU increasingly inclined to pursue directors and officers in appropriate cases, particularly obviously where the product in question is a high-profile product, maybe a children's toy, for example. And the final point, I guess, about all of this legislation is, despite the fact that it's been around for a long time, there's a surprising level of ignorance and non-compliance about it still out there in the market. So REACH itself, REACH, the acronym stands, as it says on the top of the slide there, for the registration, evaluation, authorization and restriction of chemicals. It's been around since 2007. Come back to the point about complexity, this single regulation itself, when it was enacted, replaced over 40 pieces of separate chemicals legislation in the EU. Because it's a regulation, that means it has direct effect in all of the 27 member states in the EU. It does not require, generally speaking, implementing measures. So for once, we have a reasonably harmonized regime across the EU in this respect, although enforcement is a matter left to individual member states. There is an overarching regulator based in Helsinki, the ECHA, as the slides have noted, but enforcement is a matter for individual member states. So as the first bullet there says, REACH applies to all chemical substances. That's important. This is substances, not products, manufactured or supplied in the economic area, the European Economic Area. So it's estimated that REACH will apply to approximately 30,000 different substances, and people are sometimes surprised that it applies to what they might think of as the most benign and non-hazardous materials. Particularly common inquiries for us are inquiries relating to metals, precious and non-precious metals, things like zinc, copper, cobalt. They're all covered. The one kind of standout product that, by no means the only one, but the one that people often get confused about is crude oil. REACH does not apply to crude oil as such, although if you start blending crude oil with other additives and products, then REACH may well be implicated. REACH has the effect of banning certain substances from being placed on the market in the EU. A good example would be asbestos, but it also heavily restricts the use that can be made of certain substances such as cadmium or mercury. REACH applies obligations on a variety of different actors in the supply chain. Fourth bullet there, manufacturers, importers, downstream users, and distributors all have different obligations under REACH. Principal obligations apply to manufacturers, although in the case of manufacturers not established within the EU, then the primary obligations will tend to fall either on importers or on an only representative appointed by that manufacturer in the EU. There are many, many obligations under REACH, and I don't have time to deal with them all at all. The essence of the regime is to make sure that safety and hazard information is properly passed down through the supply chain. But the chief obligation is to register substances that you supply in excess of 1 ton per year with the ECHA and to share data. And registration has been carried out on a phase-in basis. So not all substances have yet had to be registered. First registration deadlines passed at the end of 2010 and applied to substances imported or manufactured in excess of 1,000 tons or substances of particularly high concern. And David, we'll just skip over to the next slide. At the foot of this slide, you've got the dates there for the next registration deadlines, which are, there's one coming up very soon in relation to substances imported in or manufactured in in the amount of 100 tons per year, and then the smallest volumes follow in 2018. The consequence of failure to register a product is essentially that your substance, I beg your pardon, is banned from the market, and therefore if you do supply that substance and place it on the market, it will be a criminal offence. But perhaps as important is the fact that commercially, if your substance is not registered and therefore REACH compliant, if you like, you will find that it's not marketable, and commercially people will not be willing to buy those products, those substances from you. I keep saying product, that's because I'm trying to remind myself just to emphasize that this applies on a per substance, not on a per product basis. And therefore, if you have one product with 10 substances in it, you need 10 separate registrations, not one. The other important point to remember about REACH is that it applies on a per entity basis. So if you have a group of companies, if you import through one company, and then you change and you import through another company within your group, if that company has not registered the substances, or if you do not transfer the registrations to that company, you will be in breach. It is not one registration per group. Next slide, please, Dave. Perhaps before I just move on to Ross, just a couple of final points. There is a sense in which I think some people think that REACH is old news because it's been around for a number of years, and it's true that the first wave of registrations has passed, but it's certainly not true that it's old news. We've obviously got the next phase of registration deadlines coming up. We've also got a possible extension in the next few years of the REACH regime to mixtures of chemicals. And frankly, we keep getting inquiries almost on a weekly basis about REACH, notwithstanding that it's several years since it was introduced. They can range from low-level compliance issues and updating of general terms and conditions through to complex questions about blending, the implications of supplying products and substances into bonded warehouses and selling them whilst they're there, or treating them whilst they're there, give rise to all sorts of complex issues, as do corporate acquisitions and restructurings, which, if not managed carefully, can leave you accidentally in a non-compliant situation. So, Ross and Dave, how am I doing for time? We okay?
Yeah, I think they're 6-7 minutes. They're good.
Okay, perfect. That's fine.
Thanks.
So, Ross, I'd maybe take Ross and we together, because Ross and we are sister directives. We're moving with Ross, which stands for the restriction on hazardous substances, restriction on the use of hazardous substances, moving kind of maybe one step further down the supply chain from substances, the production of substances and the supply of raw substances, to the use of substances, their incorporation into products. And specifically in relation to both Ross and we're talking about electronic and electrical equipment. So Ross and we do not apply to non-electrical or electronic equipment, but for obvious reasons in this day and age, the e-market is one of the fastest growing markets, and certainly one of the fastest growing waste streams, and that's what this is all really about. It's about minimizing the use of hazardous substances in the product in the first place, so that it's then easier to manage the product at the end of its useful life. Ross is again not new. We've had it in the EU since the original directive in 2002. But the new news, and the reason this slide is headed Ross 2, is because the whole Ross regime was repealed and replaced, and indeed extended, by the Ross Directive 2011, which was finally implemented across member states as from the 2nd of January this year. Ross is, unlike REACH, a directive, not a regulation, and therefore it has to be implemented by member state implementing measures, and unfortunately that leads to a bit more of a patchwork quilt approach. And it's always important to understand exactly what the requirements are in the individual member state you're marketing into. again, it's extremely complex and has extensive guidance. ROS prohibits E from containing the substances set out there in the first and second sub-bullets at the top of the slide. There's an obvious overlap between ROS and REACH, and the key thing to understand here is that they are not mutually exclusive. Both apply. So if your product contains these substances, lead, mercury, etc., and flame retardants, PBB and PBDE, those substances will have to be registered under REACH, but you'll also have to comply with ROS if you're including them in your product. Next slide, please, Dave. ROS 2 has, as I said, considerably extended the scope of what was already a very broad directive. So in its original form, the E that was previously covered included large and small-scale household applications, so everything from kettles, toasters, through to fridge freezers, IT and communications equipment, so mobile phones, printers, copiers, PCs, TVs, lighting equipment, sports equipment, basically anything, pretty much anything you can think of that's electronic or electrical is covered. But it's been extended further, so additional new categories which are being phased in from the dates that are given there on the slide extend the scope of this legislation through also now to dispensers such as ATM machines, medical devices, including from a later date in vitro medical devices, industrial and non-industrial monitoring and control devices. And the exclusions from the scope of E are pretty tightly drawn. I won't go through the ones on the right-hand side of that slide, but not that many are excluded. And so, just to give you perhaps a bit of an example of some of the types of product where we've been asked to give ROS compliance advice in recent weeks and months, have ranged from fire alarms and security alarm systems through computer network devices, casino equipment, and even detonation equipment for use in mines. I don't know what situation is your end, but we seem to have lost slides at this end. Not that I could see them in the first place very easily. I'm going to press on and assume that hopefully everyone else can see the slides, but if you can't, well, we'll make do. For what it's worth, Dave, next slide. The ROS directive additionally imposes a whole bunch of new obligations on manufacturers and suppliers of electronic equipment that apply immediately. The extensions of scope that I described will kick in over time, but these new obligations apply immediately from January 2013. They're listed there on the left-hand side of the slide. Dave, could you perhaps just raise your arm if you can see the slides? You can, great. Okay, so I'm not going to go through those then. You can see the obligation on manufacturers now from January to impose declarations of conformity, CE marking, etc. What isn't on that slide, and is in many ways more important, is that the manufacturers, importers and distributors all now have whistleblowing duties under ROS as well. If you find that you are supplying non-compliant E, it's no longer good enough to keep quiet and hope nobody notices. You have to report it, you have to keep a record of the non-compliance, and you have to report it to the regulatory authorities. That's not just the manufacturer, but also people to whom you supply. The offences under ROS are virtually strict liability. The only defence is that you can show that you took all reasonable steps and exercised all due diligence. Knock-on consequences of breach are significant, not just in terms of criminal penalties, but, for example, invalidation of insurance, revocation of trade licenses possibly. And in our experience, the most likely cause of non-compliance is actually not mistakes by manufacturers, it's defective supply of products by those who supply to the manufacturers of these products. Most commonly, you will find that rogue substances or the wrong amounts of substances creep into products particularly supplied from the Far East. And therefore, one of the key lessons in relation to ROS is to make sure that your supply chain arrangements are appropriate in terms of warranties and indemnities from those supplying raw products to you, audit and inspection rights to go and audit your suppliers, requirements on suppliers to help cooperate with you in the event of an enforcement, and to make sure that you, as the assembler of the product, have in place protocols for regular testing, sampling of products. Now, I'm not going to dwell, because we're short of time, on next slide, please, Dave, which, if that isn't a slide about we, then it should be. Sorry, I still can't see anything, but I think there's enough said on the slide there. We has been around, again, since 2002. In essence, we is an obligation on producers and suppliers of E to pick up the costs of collecting it at the end of its useful life and treating it, processing it, and disposing of it or recycling it appropriately. Generally speaking, we compliance is achieved through producer compliance schemes. Most people that this affects are already members of compliance schemes and pretty up to speed. And of the three areas, this is the one probably that generates the least difficulty, I would say. And it's due to be, there is a new WE directive, but it's not due to come into force until February 2014, so that's another reason for not dwelling on it in too much detail. There's a bit of information about it on the final two slides there. The final remark I would make, and then I'll hand over to the next speaker, is in relation to WE in particular, since the new legislation has not yet been implemented, but in all of these areas, and I say this always, but it's so true, most environmental legislation in the EU now emanates from the European Commission in Brussels rather than at member state level. The time for influencing the shape of that legislation is way before it ever hits the statute books. It's before it's even published in draft. It's when it's first a twinkle in the eye of the European Commission. It's when they produce white papers and green papers setting out their proposals. If you are affected by, or might be affected by, new legislation coming down the pipe, you have to be lobbying through trade associations or individually to shape that legislation in the form that works best for you, because by the time it emerges as one of the directives I've been describing, then it's too late. And talking of too late, I've finished and my slides have just popped up, so I will hang back to you, Dave.
Great. All right, so thank you, Nick, and then we're going to go to California now with Jamin Bullock and green chemistry. Jamin?
Thanks, Dave. So I'll be talking a little bit now about how California may be trying to follow Europe's lead with respect to how it regulates some of its products. And so I'll be talking about the Green Chemistry Initiative in California. And a lot of people haven't heard of green chemistry before, so I'll just start off with a general overview of the topic, just to familiarize the audience. So generally, the concept of green chemistry, which is also known as sustainable chemistry, is the design of products and processes that reduce or eliminate the use or generation of hazardous substances. And in doing so, green chemistry encourages the design of safer chemicals and products. Now, green chemistry applies across the life cycle of a chemical product, including its design, manufacture, and use. But the focus of green chemistry is really on the design stage of the product rather than at the disposal stage. The purpose of green chemistry is to minimize the impact of chemicals on human health and the environment through the design of safer chemicals and products, the reduction and elimination of certain hazardous substances, and the design of chemical products that degrade after use. The purpose is also to move beyond the current system of chemical by chemical bans that we currently have in the United States and try to apply REACH-style requirements here in the US. And green chemistry is also promoted to industry itself as a way for industry to reduce waste, to eliminate cleanup of hazardous waste, which is expensive, produce safer products, reduce the use of energy and other resources, and improve the competitiveness of US manufacturers. So why is California moving ahead with green chemistry now? Part of the answer lies in the federal government's primary law dealing with the production and use of chemicals, which is TSCA, the Toxic Substances Control Act, that was passed in 1976 and has become seen by many as an inadequate and obsolete tool for providing for protection against risks posed by modern chemicals. Efforts to modify TSCA at the federal level have failed, which has prompted other regulatory entities, including states, to propose other alternative ways of protecting against the risks from chemicals. Now, at the federal level, EPA does have a green chemistry program that is run through its Office of Pollution Prevention and Toxics, but that program is voluntary and non-regulatory and involves partnerships with academia, industry, and nonprofits. And that has left some people in the regulatory realm to be dissatisfied with it, which has prompted California to institute its Green Chemistry Initiative to move beyond that voluntary approach. The Green Chemistry Initiative in California got its formal start in 2008 with the passage of AB 1879 and SB 507. I'll just talk about them briefly to provide some context. AB 1879 requires DTSC to evaluate and prioritize the most significant harmful chemicals and also gave DTSC the authority to regulate those chemicals. It also set up an Environmental Policy Council that oversees the program and a Green Ribbon Science Panel that guides research on chemical policy. And additionally, SB 509 set up a Toxics Information Clearinghouse that provides information regarding hazard traits and toxicology and other information to businesses and the public. Although the Green Chemistry Initiative was originally scheduled to go into effect in 2011, there has been considerable delay in the rulemaking process due to concerns by stakeholders on both sides of the issue, environmentalists and businesses, that have led to a lot of delay. So after multiple proposals and nearly 4 years of public consultation, DTSC has issued a revised set of its green chemical regulations in January. It's referred to as the Safer Consumer Products Regulations, and the regulations are intended to motivate manufacturers of consumer products to seek safer alternatives for some chemicals. And it will eventually require manufacturers to reduce or eliminate particular chemicals of concern from an array of consumer products. The most recent draft of regulations was published on January 29th, and the public comment period closed on February 28th. And most observers expect that this last revised set of regulations will be the final draft, with regulations going final sometime this summer, probably in July. The regulations apply to consumer products that contain a candidate chemical or a chemical of concern and are sold, manufactured, distributed in California, with some very limited exceptions. There's only really 2 exceptions. One set of exceptions is for food, pesticides, and prescription drugs and medical devices that are regulated in other ways. Another set of exceptions is for products that are regulated by other laws that provide equal or greater protection. So essentially, the Green Chemistry Initiative is meant to establish a floor, but not to conflict with other regulations. There is no longer an exception for products that are simply manufactured in California or transported through California that aren't intended to be used here. There had been an exception for those kinds of products in another draft, but that exception was taken out in this last final draft. Next slide, please. So the regulations set up a 4-step process, essentially. And the first step is that DTSC, the Department of Toxic Substances Control, will issue a list of so-called candidate chemicals. And it's an initial list of approximately 1,200 plus chemicals that is based on existing authoritative lists, including California's Proposition 65 list. And this slide here shows you an example of some of those lists that DTSC is relying on in drawing up its list. And as you can see, some lists have more chemicals and some have fewer. And so DTSC will be choosing from chemicals on this list based on exposure traits, exposure and hazard traits to develop its list, which has not come out yet. Chemicals also will be added to the list in the future based on their potential to cause adverse effects rather than just their ability to cause adverse health effects or environmental effects. This second slide here illustrates the second step in the process, which is the selection of so-called priority products and chemicals of concern. So you see you have all chemicals and then a set of 1,200 or so candidate chemicals that are based on the list from the previous slide. And then next is a subset of products, priority products with so-called chemicals of concern. DTSC is going to focus from that 1,200 or so chemical list to 230 chemicals or so based on sort of elevated exposure and hazard traits, and then use that list of 230 to focus on an initial set of 5 products in the first year and more products after that that will be considered priority products. And that will then trigger the next step in the analysis, which is alternative analysis and then eventually regulatory responses. Next slide, please. So as I said, so the first 2 steps I just talked about. The third step is the alternatives analysis, in which manufacturers have to look at a product, determine whether there is a chemical of concern in the product, what risk that chemical poses, how exposure occurs, what the impact to the environment and health is, and whether there are alternatives available for the chemical that's in the product. And essentially, an alternatives assessment, it's a very long, detailed, and drawn-out process with many, many pages in the regulations, but it essentially comes down to 2 steps. The first step is a preliminary analysis, in which the manufacturer has to determine whether there are alternatives available to the chemical of concern. And then the final step, the final analysis, is to evaluate those alternatives to the chemical and determine whether alternatives are reasonable and viable. And this whole process, once an alternatives assessment begins, is subject to public comment. The final step is the agency response, in which the agency can take a whole host of actions based on the conclusions of that alternatives assessment. And those actions can include simply requiring notice to consumers, similar to what happens under Prop 65 now, establishing a stewardship program for what happens to the product at the end when it's disposed of. DTSC can restrict the use of the chemicals that are in the product, or it can simply ban the product altogether in California if that is what it determines is best. And again, this whole subject is also, or this whole process is also subject to the public comment process. Next slide, please. Now, responsible entities who have to comply with this process include many sets of entities in California: manufacturers, assemblers, importers, and retailers who sell the product. But the principal duty to comply is with the manufacturer of the product, and the manufacturer really has to take the lead in complying with the regulations. The compliance obligations really only fall to the importers, assemblers, and retailers if the manufacturers fail. So it goes manufacturers, then importers, and then assemblers and retailers. And if the manufacturer has failed to take responsibility, DTSC has to put it on a list, and then the others have to step in and start complying with the law. And the responsibilities, primarily for the manufacturer, but possibly for others, include notifying DTSC that one of their products is a priority product on the priority product list, then performing the alternatives analysis, submitting all of the required reports to DTSC, and complying with DTSC's regulatory response at the end of the process. As you can imagine, businesses have a lot of concerns about how this process is going to impact them. The first of which, of course, is the cost of compliance due to the unpredictable costs related to testing, data collection, expert analysis, reporting to the agency, and some companies may not have the financial resources needed to comply with this law. The second concern that businesses have is due to the existence of conflicting and duplicative regulations. We've seen other states move forward with their initial green chemistry initiatives. We have Europe with its REACH laws, and businesses are concerned that there's yet another list of chemicals that they have to collect data on and perform analysis on. And we can only expect that other regulatory agencies are going to be taking similar actions, which will lead to a proliferation of these kinds of programs in the future. And finally, businesses are concerned about confidential business information and trade secrets and how this will impact those. The alternatives analysis requires industry to provide detailed information about the chemicals and potential alternatives, including the identity and composition of those chemicals, how the chemicals perform, the manufacturing process, potentially customer lists, and most businesses consider this kind of information to be confidential business information and trade secrets, and public disclosure of this information could have severe economic consequences. Now, the revised regulations attempt to deal with this issue in a couple of ways. First, by recognizing that a manufacturer may not be able to submit the required information to the agency based on federal law or based on their non-disclosure agreements, and also allowing a manufacturer to mask the alternatives that are put forward in the assessment if a patent application is pending. But despite these safeguards, businesses still remain concerned about how this will impact their trade secrets. Next slide, please. I think you skipped one. I'm going to kind of skip this slide anyway, but I just wanted to provide it in case you had information about it. This is just a list of how the regulations have changed over time and what is in the new final regulation that wasn't in the old one. I'm not going to really dwell on it except to point out that the new regulation has added the public comment process and APA rulemaking process to a couple of steps, including the selection of priority products and how the alternatives assessments are done, which businesses need to be aware of. Next slide, please. And so what to expect next? So the public comment period closed on February 28th. DTSC will respond to those comments in what's called a final statement of reasons that we can expect to come out this summer. At that point, DTSC can formally adopt the rules as final, and again, we expect that to occur in July. About 30 days later, the agency will release its initial list of candidate chemicals, and then issue also with that a 6-month forecast for chemicals that may be added to that list. DTSC will then begin focusing on the priority products and chemicals of concern that it will look at in the first year. That list also is yet to be announced. DTSC will issue its list within 6 months. That's the initial list, and then a final list of priority products will come 3 months after that, with more products to be added over time based on a 3-year work plan. And so after that, once the priority products are issued, manufacturers will then have to begin the alternatives assessment process. And next slide, please. And so at this point, given that we're still early enough in the process for industry to start addressing how to implement it, there's a few things that businesses can do. The first is to take a look at the list of potential candidate chemicals that is published on DTSC's website and identify any of those chemicals that are in your product that could potentially become priority products. And if there are chemicals on that list, then to start taking steps to plan for the alternatives assessments. Again, they take a long time, they're expensive, and you may not have enough time to do all of the data collection and expert advice that is required in an alternatives assessment. One thing that small businesses that might not be able to afford it can do is form consortia with similar businesses where they can pool their resources to try to address and submit the information that is required. Larger businesses that can afford it should look at the green chemistry principles on which the initiative is based and start integrating those principles now in order to prevent having to go through the alternatives assessment process later. And also businesses should start looking at the fact that you can establish that certain chemicals in your product that might end up on the list there could be no viable alternatives to them, or they might be necessary for the product. So even though the regulations are intended to replace certain chemicals, you can start establishing a record for why those chemicals need to be in your product and can't be removed. And also finally start planning for addressing trade secrets and putting non-disclosure agreements in place. And that applies to manufacturers as well as retailers and importers. So I'm over my time, so I'll send it back to Dave. And if you have any questions, please give me a call or send me an email.
Nick and Jamin, thanks. That was great. And I think what's interesting is you have more than one entity forcing greater product scrutiny for manufacturers, producers, retailers, importers, exporters, distributors, suppliers. You have the U.S. government, the SEC, focusing on conflict minerals. You have California, by the way, adopting a prohibition that state agencies can't sign contracts with companies that haven't complied with the federal conflict minerals rule. You have the European Union, forcing change with chemicals and material restrictions. You have California trying to make their rules more like the European Union's rules. You have talked on Capitol Hill about amending our chemicals law to make it more like the European Union's chemical law, the REACH law. So there's multiple pressure points, and they're all coming down on the same big universe of entities, of companies. The last piece, and I'll hit this quickly, Nick talked about the cradle to grave. We're now at the grave. What do you have to do at the end of the life cycle? What are your requirements? And you'll see, first of all, that we talked about European Union. In the U.S., there are 25 states with EWaste laws. Also Canada, increasingly in Asia and Pacific, and in Latin America. And they focus mostly on batteries and electronic and electrical products. And you see some of the same elements in these. I'm talking about the 25 state laws. Requirements for the sale of new products, registration, administrative or other fees, labeling requirements, collection programs, and then performance and reporting requirements. Here's a nice map of the 25 jurisdictions that have e-waste laws covering 65% of the population. California is a different color. I'll tell you why in a second. Typically, you have two kinds of e-waste laws. The majority, 24 jurisdictions, put the burden on the manufacturer or the producer to develop a program to take the waste back. A few states, the government will manage it and then bill the manufacturer. And I think one jurisdiction gives the manufacturer a choice, do it themselves or have the government. But predominantly, it's producer responsibility. And again, these nuances vary from state to state, whether it's the list of what they regulate, what they require from registration, what products they regulate. The Advanced Recovery Fee Program, that's California's program. In this case, the consumers pay a flat rate at the point of sale on certain devices. But what the result is, it's your true patchwork legislation. There's different approaches. Products are covered differently. Some statutes include laptops, TVs, monitors. Others don't. Some states, like New York's new law, captures the smallest, the iPod Nano, that's the smallest, I'm not really sure. Other states, not so. For example, we had a client, looked at every state law. They wanted to market an e-reader with a 5-inch screen, and we had to figure out which jurisdictions captured that 5-inch screen. Some did, some didn't. Others said, well, e-reader, okay, but if you make it more of a laptop, have some moving images on it, well then we'll regulate it, screen size notwithstanding. Another client looked at, can you resell a returned consumer electronic good that hasn't been used or was lightly used? So there's all these things that haven't even really been fully contemplated by some of these laws. So to sum up here in the last 1 minute, we have, as we talked about, more regulation of product life cycle. We have requirements far from home. We have issues with contracts, purchase orders, etc. Documents that aren't always getting the right legal scrutiny. Unresolved enforcement or liability or damages issues. And what does that equal? Well, arguably, squirrels with lightsabers. I had this in. I showed my 8-year-old son this last night, and he had two reactions. One, why aren't they actually fighting each other? Like, why isn't it a video? And I couldn't make that happen. And two, I said, is it too silly to leave it out? He said, it's the coolest thing in the whole report, all right? With all due respect, it's the coolest thing in the whole report. So actually, if that were the case, we'd have bigger problems than conflict mineral reporting. But what we urge you to do is figure out your legal requirements, your exposure. It's all about the supply chain, right? That should be the takeaway. Look at the drivers of regulation and market trends, and I think social forces as well. And then going forward, more markets are going to adopt these rules. I'm certain of that. In the U.S., as I mentioned, the conflicts minerals litigation, you have possible reform of our chemicals law in this country. Jamin mentioned the regulations under green chemistry coming up pretty soon. More state bans. Certainly please call or email. We also plan to, over the course as these issues become sort of a bigger deal or a flashpoint, we'll have maybe a 30-point teleseminar to get you caught up on these developments. So with that, I thank you for your time, and have a good afternoon, morning, whatever it might be. Bye.